Well, good afternoon. My name is Matt Parker, and welcome to the webinar, When is an Asset Protection Trust Appropriate? I am here today with my longtime co-worker, case manager at the firm of Marshall, Parker & Weber, Patti Jo Turner.
Good afternoon.
And we are here today to discuss asset protection trusts. We're going to go over what are they, when to use them, who would be a good candidate for these trusts. One of the things I think we ought to clarify before we get started on these trusts and how they operate is to distinguish other types of asset protection trusts from the types of trusts we use at Marshall, Parker & Weber. You know, our firm is an estate planning and elder law firm here in Williamsport and also Wilkes-Barre. We tend to deal with clients of modest wealth, and they're typically interested in protecting home or assets from the cost of long-term care. There are other types of asset protection trusts out there. They have different names. I know them by the term the Delaware Asset Protection Trust. And those types of trusts are typically for the wealthier individuals in our community, and they might be interested in protecting assets from other concerns, be it lawsuits or claims of creditors. So we don't do those types of trusts here at the smaller law firm of Marshall, Parker & Weber. We tend to be working with people who are concerned about long-term care costs. And so that's the type of trust we're going to be talking about here today. Okay, so let's begin the presentation. And first, the question is, what is an asset protection trust? Trusts can be drafted in all types of different ways. Some are revocable trusts. Others, as in this case, are irrevocable. With these irrevocable trusts, we are attempting to remove ownership of some assets of our clients from their names into the asset protection trust. With these asset protection trusts, you want to protect some of your savings, perhaps it's money or investments, and perhaps your home, from some financial risk. Typically, it's the cost of long-term care, what we might refer to as nursing home costs. So you want to protect some of what you've saved over these years to the potential risk that could happen to you in the future. You don't want to lose everything you've worked for your entire life. So you need to transfer ownership, literally give up ownership and control to a degree of some of your assets in an effort to protect them from the cost of care that may occur years in the future. So the Asset Protection Trust is one way to accomplish this. Rather than giving, let's say, the home or some of your savings directly to children, you can create an asset protection trust and give to the trust what you want to protect. This avoids giving assets directly to children, where your home or savings could be exposed to the risks of their lives. And Patti Jo, you've been involved in our firm now, I think it's close to 20 years, and you've been doing the funding and helping attorneys create these trusts for some time. What are some of the things that you've seen that our family is concerned about when they talk about giving assets to children?
Well, the problem is when clients are thinking of making a gift directly to their children, they're basically making a gift directly to all their children's possible problems as well. The possibility of a divorce, financial problems, bankruptcy, a penchant for the ponies, as it were, or even having a child unexpectedly predecease a parent might impact what happens to those assets, or they might even just have a falling out with their parents. The benefit of transferring assets to a trust instead of to the children is that the kids don't actually take ownership of those assets until after both of the clients have passed away. The trust will own those assets until the settlors have died.
Great. So when we're talking about asset protection trusts, I think the listeners need to distinguish between trusts that can literally protect the assets, like irrevocable trusts, and those that are revocable that we can easily undo whenever we want. So keep in mind the different types of trusts that we're talking about here. Okay. Why are these asset protection trusts so popular? One of the reasons they become so popular is the cost of long-term care keep increasing every year. If you're not aware, the cost in Pennsylvania per month for nursing home care has now reached $10,000 per month. In a year, of course, that cost can will be over $100,000. The average person just doesn't have that sort of money tucked away to pay for the cost, that type of cost of care. So typically somebody's interested in applying for government benefits to help them pay for care. Unfortunately, Medicare has very limited benefits for nursing home care. Medicare will pay for hospitalizations and doctor's visits, but has limited benefits for nursing home coverage. So the program most applicants turn to is the Medicaid program. Medicaid is an asset-based program. If you have too much money in savings, you're not going to qualify for Medicaid. There are assets that the government counts to determine if you're eligible for this program. They are typically your liquid assets. Think of your savings, your stocks, your bonds, maybe deferred annuities. All of those can be liquidated and used to pay for your care. If you have too much of these at the time you apply for Medicaid, either you or your spouse won't qualify, and you'll have to spend some of this money on you or your spouse's care. So one of the goals of using an asset protection trust is to reduce the size of these countable assets. So if you apply years from now, you will have fewer assets in your name, and therefore it will be easier to qualify for Medicaid. Now, there are also assets that are not counted, and the most popular of those is the house. This an applicant can keep in most cases and still qualify for Medicaid. However, Medicaid has something called the Estate Recovery Program. If you own an asset when you apply for Medicaid, such as the house, it could be subject to a lien at the time of your death. This is a lien up to the amount of Medicaid that you received during your lifetime. So although you don't have to sell your house to qualify for Medicaid, your estate might have to sell your home after you die to pay off the lien. Thus, the other popular use of the Irrevocable Asset Protection Trust is to protect not only some of your savings, but your home. If you put the home into the trust, you can protect it from this Medicaid Estate Recovery Program and the government's lien. So, when are these asset protection trusts used? The key to planning to protect your savings and home is, of course, to plan ahead. It's much more difficult to protect assets at the time of your admission to the nursing home, although there's some very creative planning that can be done to shelter assets, particularly for married people. If you really want to preserve assets from the cost of your long-term care, you need to be planning ahead. One of the reasons is that the transferring of assets in an effort to protect them from the cost of your care could make you ineligible for Medicaid. The Medicaid program has something called the 5-year look-back period. This is a time frame when the government can ask, what did you do with your money or your property? If you happen to have given it away within those 5 years, the government has the right to say, hey, you're not eligible for Medicaid. Now, you're not ineligible indefinitely. There's actually a calculation they'll do to determine how long you're ineligible, but the more you give away, the longer you are ineligible for Medicaid. And the government does consider all those gifts you made within the 5 years prior to your application for benefits. Now, transfers to an irrevocable asset protection trust are subject to the 5-year look-back period. You do have to report a transfer of your home or your savings to an asset protection trust. However, if that transfer was done more than 5 years ago, you don't have to disclose those transfers. And then what has been sheltered in the trust is then protected from the cost of your care. So, Patty Jo, you've been seeing clients for, again, quite some time do this sort of planning. When do you see most of them starting to say, hey, I think maybe we should think about creating one of these trusts and start transferring maybe just a house? That seems to be the most popular asset. When do they start thinking about that?
There isn't a hard and fast rule, but I do see a lot of people starting to contemplate this right as they are about to retire or have just retired, because a lot of these decisions and future planning are on their minds. They're looking at, so now that our income's changed or our family's changed, that's a time when people tend to reevaluate and want to make some forward changes. And oftentimes there may be a series of health issues that occur that kind of makes people take stock of where they're at and where they're going. That's another thing that drives people to think about this.
You know, one of the things I've seen, Patty Jo, is that if our clients' parents have needed care in the past,
Yeah.
they're acutely aware of the cost of care and how assets had to be sold to pay for their parents' care. So the retirement age seems to be a popular time to at least start thinking about how are we going to deal with our care 20 years in the future if we need nursing home care. Are we going to sell our assets? Or maybe we should start thinking about one of these trusts and protect assets now while we can make it through the 5-year look back. And keep in mind, it used to be 3 years, Patty Jo, for the look back. It's now 5.
I remember that.
Yeah. And it could be 7 or 10 in the future. So, all right. Now, here's a great question for Patty Jo because she gets involved in the funding of these trusts with the clients. Every client's a little different as to what they want to put into the trust. Often our clients will want to put a house and nothing more. Other clients will have investments. So Patty Jo, maybe you can tell me a little bit about what you've seen in terms of the funding of these trusts. What typically goes into them?
The house is by far the most popular asset for people to put in a trust. Lots of folks have additional properties, either some mountain land that's the family goes hunting on, or they've got a place down at the shore. Sometimes that's an extra piece of real estate that they're looking to protect. And in terms of liquid assets, there's a lot of folks that have a fair amount of insurance policies that they've had forever. They're continuing to grow and build value, and they really don't think about those policies very often. So that's an easy asset to put over into the trust and have almost no impact on the clients as well. And then if they have a little slush fund or a side account that they've put aside for a rainy day and really have no intention of dipping into, barring some extreme circumstance, that's an asset that they tend to like to protect as well.
Now, the beauty of putting a house into the trust is very little changes in your life. You still get to live there for the rest of your lifetime. In fact, the trust does say that. And in fact, the trust allows you to sell your house. You could be sold in the future. A lot of clients do ask, could I sell the house and downsize? And they can do that, can't they?
Absolutely. Yeah. The house can be sold within the trust, and maybe the next place they're moving to costs less. So the new house can be purchased right within the trust, and the excess money stays in the trust and stays protected. Or it may be a case where they don't want to purchase another piece of property, but at least there's a nest egg here that's now been protected and may help fund the living expenses going forward.
And one of the questions I get asked is that affect the look-back period if you sell the house while it's in the trust, and it does not. The only time the look-back period comes into play is when you move the house into the trust initially. Now, some of our clients say, hey, can I get a reverse mortgage or some sort of loan on the house after it's in the trust? Can that be a problem when it comes to dealing with banks if they have to deal with an irrevocable trust?
They can. I'll deal with those separately. The reverse mortgage, that is not something that a client can pursue if their house has been put into the trust, because technically they don't own it anymore. So the reverse mortgage is a hurdle if it looks like that's on the horizon. In terms of owning a piece of property and wanting to take out a home equity line on the house, occasionally the banks are less eager to work with them, even though the value of the house is the same. It's harder for them with all the new regulations to issue that line of credit when the house is owned by a trust rather than an individual. Yeah. There are some that will do it, but it's more cumbersome.
Yeah, the irrevocable trust does seem to create problems for some banks and credit unions. So, and the reverse mortgage situation, I think by statute, you have to be the owner of the house to get a reverse mortgage, and so these irrevocable trusts are kind of different, a different way of protecting assets than a reverse mortgage. So, so you don't put everything into these irrevocable trusts. Popular assets are life insurance policies, stocks and bonds, deferred annuities, other real estate. anything it's you're not going to use on a regular basis to pay for your expenses, and you want to save it for yourself. And typically you're thinking of saving it for the next generation. So you're not going to put everything into the trust, so think of this as long-term savings that you're putting into your irrevocable trust. So what not to put into the trust? Here are some of these popular assets that just typically don't go in, and maybe Patty Jo, you can fill in some reasons why these assets wouldn't typically go into the trust.
All right. The number one asset that should not go into the trust is a retirement account, an IRA, qualified funds. They don't fit well with this kind of a plan. There's some tax implications that would happen if you were to transfer them into the trust, and it would just never be a good outcome under those circumstances. The other things that don't make sense to put in would be your day-to-day checking and savings, or even a larger savings account that you keep on hand for things like a new roof or a new car, larger expenditures, but not a crisis. So we would never recommend anyone put everything into the trust. They should always keep out enough so that they can continue to live day to day without any strings.
Yeah, you don't want to be asking the irrevocable trust for assets to be returned, because it's very difficult to do so. Now we'll talk in a slide or two about the removal of assets from these trusts, but this is not a slush fund of yours that you can just use on a regular basis. So you need to keep assets outside of the trust that you're going to use for various expenses that do come up. And also, of course, cars don't go into an irrevocable trust. I suppose there could be people who have collectible cars that could transfer these to an irrevocable trust, but generally they're not used to shelter cars or personal property, because Medicaid just doesn't count your personal items at home, so those are typically not put into a trust. So what about some of the tax issues that come up? I get asked those a lot by people who are creating these. Thankfully, these types of trusts that we create for our clients are what the IRS calls grantor trusts. Whoever creates these trusts, and you're known as the settlor or the grantor, you are the party that's taxed whenever there's any income earned in these trusts. So if you create one of these trusts and you transfer some stock that's producing dividends, you are still taxed on the dividends that are generated by the stocks in the trust. So you're going to report the dividends on your personal income tax return. There are some additional forms that have to be filed when you create one of these trusts, but you are still the taxable party, you, the settlor. So you don't have to worry about the income being passed on to your children. That's one of the great concerns my clients have, that somehow the kids' lives are going to be involved. Not the case. And there's no increased tax rate here. So there are some trusts out there that pay very high taxes. This is not one of those trusts. These are what we call grantor trusts, and the taxes are taxed to the grantor. The income is taxed to the grantor at the grantor's tax rate. Now, at your passing, the assets in these trusts will pass on to beneficiaries. These are not the type of trusts that go on for generation after generation. They typically end at your death. So at the parent's death, if they fund the trust with the house and some of their savings, and the parents die, the trust ends, and the assets in the trust pass on to beneficiaries. If they're passing on to children or grandchildren, there will be some inheritance tax paid here in Pennsylvania. It's not the really high estate tax rate that the federal government has. Here in Pennsylvania, we have a 4.5% inheritance tax rate when assets pass to kids and grandkids. And for those financial advisors and accountants up there is a step up in tax basis on the appreciated assets in this trust at the settlor's death. So if there's a house or stocks in the trust, there's going to be a step up in tax basis, and hopefully no capital gains tax issues at the time the assets are liquidated after the settlor's death. So they are very tax-friendly trusts for anybody who is concerned about the tax consequences. Now, who can be the trustee? The trustee is the manager of the trust. With these trusts, the trustee often has very little to do. Keep in mind, these trusts are like holding areas for the money or investments. There are not going to be distributions during lifetime to the settlors. Unlike some trusts that are operating trusts where the assets are being distributed to a beneficiary on a regular basis, these trusts are intended just to hold real estate or hold investments, and then when the settlors die, they pass on to the beneficiaries. So typically you don't have professional trustees involved. Most of these trusts will include real estate, and that's one of the impediments to have a bank or other professional trustee involved. And quite frankly, there isn't a lot of work to do. So again, that's another reason why the professionals will not be involved. Typically, these trusts are managed by the children. You can name one or more of your kids to act for you. You can name co-trustees, two or more trustees to act together. So you have some flexibility to design how the trustees will be working for you. Keep in mind, you can always remove the trustee and replace them with different trustees. So you're not married to the child or children that you start out with. You can always change down the road as your relationship changes with your kids. So that comes up periodically, Patty Jo. I mean, you mentioned that you might have a falling out with a child, or maybe they married the wrong person, and there's some undue influence there, if you will, with the child you named as your trustee, and you're concerned about it. So you can always rearrange the trustees down the road. Now here's something I alluded to. Can you remove assets from the trust? I did also mention these trusts are not intended to be your personal piggy banks. You're not supposed to put money in one day and then take it out the next day. If we're going to make these asset protection trusts work, we must make the assets in the trust unavailable to the person who created them. Otherwise, when you go and apply for Medicaid and the trust says pay everything to the settlors, well, the government's going to say it's all available to you, and you've protected nothing. That's why revocable trusts, by the way, don't work to protect assets. You must have an irrevocable trust to preserve assets from the cost of your care in a nursing facility when you apply for Medicaid. So one of the terms of the trust will say, under no circumstances can what you funded the trust with be paid back to you, the settlor. You cannot have the trustee just give you back what you put in here whenever you want it. Now, that said, we do build in some language to these trusts that say, hey, if the settlors want to distribute assets in the trust to other people, like children or grandchildren, they can do so. So even though the trust says the assets in the trust cannot be returned to the settlors, they can in fact be given to children or grandchildren. What the children or grandchildren do with these assets once they receive them is totally up to them. I've seen cases where trust assets have been given from the trust to a child, and then those children voluntarily use the funds for the parent's benefit. It could be paying for care in another context other than a nursing home. One of the things you have to be aware is that Medicaid is really a popular benefit for nursing home care, but it doesn't pay for personal care homes or assisted living facilities. And it has limited benefit for home-based care, so there may be some other reasons why you need to use what is in that trust for the settlor's benefit. So sometimes the money is taken out of the trust and given to a child who then turns around and pays for the expenses of the parent's care. I had a case not too long ago where the mother went to an assisted living facility, and periodically money would be removed from the trust and then paid to the assisted living facility for that parent's care, because most of the savings were in the trust. Perfectly allowable, but you just can't have any strings attached to the settlor that says the child can or should use the money for the parent's benefit. It has to be totally voluntary on behalf of the child. Right. Oh, and one other point about this, the child can't just take the money out of the trust at their will. It has to be the settlors, the parents who created the trust, or the parent's agent under a power of attorney. So you can't just, in most cases, just give the child the power to take the money out at their will. If you do that, typically it's a group of kids, a committee, and the majority of them would decide to take money out. Patty Jo, anything that you want to add to this?
No, just that there are situations when a family wants to, in that situation where someone's in the assisted living, the funds can be directed out of the trust to one of the kids who can then pay the assisted living or for the extra nursing care on the child's behalf. They can do that. There's also situations where the family wants to help a child who's come on financial difficulties or maybe has some extra medical expenses of their own. That's another reason that people sometimes want to have assets come out of the trust.
Yeah, gifting to kids for college expenses comes up. Sometimes it's the grandkids. Sometimes families just get through the 5 years and they don't see any reason to keep the trust going, and then they liquidate it and they distribute the assets to the children. So that's some of the things that we see with our clients. Well, that gets us to the big question, who should be creating these trusts? I think as we've discussed, it should be somebody who's really ready to give up ownership of some of their savings or their real estate. They need to be comfortable with giving up that control and ownership. If they're young enough and they're just not comfortable with giving up that control, then they shouldn't be doing this. And the idea of creating an asset protection trust is sort of a middle ground between holding on to the asset and fully giving it to your child. It's kind of an in-between situation. You've given it to the trust and retained some benefits from giving it to the trust, such as the right to live in your house for the rest of your days, and your kids only get what's in the trust at your death. So you haven't totally given up control, but there certainly is a degree to which you have given up ownership of these assets. And secondly, you want to protect some of your savings for the next generation. Gosh, Patti Jo, we run into clients and say, if it's all gone, too bad for the kids.
It's all gone.
It wasn't intended for them in the first place. So if you have no desire for asset protection for that next generation, well, this doesn't make a lot of sense. So most of my clients are saying, you know what, I put a lot of time and an effort into saving money and protecting and paying the mortgage and putting some money away. I'd like to see some of it pass on. Maybe not all of it, but some of it will pass on to the next generation. And lastly, people who can get through that 5-year look-back rule. These trusts are not for the very ill individuals who families come in at the 11th hour and say, Mom never wanted to give up control and now she's in a nursing home. Can we get through the 5-year look-back? Well, first of all, Mom has to be competent and be able to do this planning. And second of all, you've got to hope she gets through the 5 years. So one of the asset protection concepts we haven't talked about today is qualifying for veterans benefits. And right now, the Veterans Program does allow you to transfer assets without a look-back period and get a pension called aid in attendance. And so one of the other reasons that people create these trusts is to qualify for a pension benefit from the VA. It could be the veteran or it could be the widow of a veteran, and they're typically in an assisted living facility. And so they're transferring some assets to the trust, and then right after they transfer the assets to the trust, because there's no look back, they can then go down and qualify for aid and attendance, provided they meet the other income test for that program. So it does accomplish something else other than just qualifying for Medicaid in the future. You might have an aid and attendance situation. And something that came up not too long ago, Patti Jo, that isn't not the intended result here, but once you put assets into the trust, you can't just get them back. So if we have a situation where the married couple puts assets in, and then there's a death, and then the older gentleman meets a younger woman, let's just say. I'm not
He
going to
does, yes.
say that happens all the time. The older gentleman then meets somebody at church or a social function, he gets married, and he wants to give his house to this new woman that he met. But
Yes.
you can't do that with this trust. So it's sort of like a post-nuptial agreement in some ways.
And it removes the stigma of having to say, I can't, because it's already done.
It's already in the trust and you can't get it back without the kids okay. So it's not going to happen if you remarry. Okay, well, we've reached the end of the presentation, and if you want to learn more about these trusts, don't hesitate to give Marshall, Parker & Weber a call, or visit our website at paelderlaw.com. You're going to find lots of articles on these trusts and other planning ideas, so don't hesitate to visit it. On behalf of Patti Jo and I, thank you so much for attending.